in front of such an august gathering, even though we sort of fluctuate in terms of augustness. It is an interesting topic. Some people are more august than others. Where's the Chief Justice? I mean, no offense, Lord Goldsmith. It's her jurisdiction, I want you to know that. So, thou shalt not interfere. And for those of you who've read the BBI Arbitration Act 2013, if you haven't got the message that the court should not interfere, you clearly haven't read the various places that appears. The Act is interesting in that it talks in Section 10 about what Article 5 says, which is the court should not interfere, but also it appears, as I've discovered, in Section 3(2) of the Act, where, as I say, it repeats again, do not interfere, courts. This Act is founded on the following principles: subject to the observance of the safeguards that are necessary in the public interest. The parties to a dispute should be free to agree on how the dispute should be resolved. B, the court shall not interfere in the arbitration of a dispute, save as expressly provided in this Act. And where it does interfere, it should give full regard to the wishes of the parties. Over the years, various judicial expressions have been made about the court's role. And here's Baron Mustill, who passed away last month, a central figure in arbitration for many years, author of the leading textbook, Mustill and Boyd. And as you see, his view of it was about the delicate balance, the urge of judges to see justice done. Jan Paulsen, professor in the University of Miami, well-known arbitrator, probably one of our more distinguished living arbitrators amongst those in the room today. He says the great paradox of arbitration is that it seeks the cooperation of the very public authorities from which it wants to free itself. So we've had this contest between arbitration and the courts for many a year, and if we can do our math right, it's like 406. As you see, Vinor's case, all the way back then, was that an arbitration clause, if it was in an agreement, was revocable by a party. And that was because, A, the courts felt that they were created by the king, they spoke for the king, and B, I'm not sure what it's like here in BVI today, but the bigger the caseload, the greater the salary. And I am told reliably that that's no longer the case. Is that right, Dawn? So there was an interest in the courts in keeping arbitration down, not to encourage it. We have this interesting hands-free sort of way of moving the slides. So the sea change, as I describe it, and this was actually a case about some chartering of vessels, was in around 1856 in the case of Russell and Pellegrini, about if the parties had bound themselves to do arbitration, why should the courts interfere? And there, for those with good eyesight, I don't know, is it readable at the back? Is that a yes or a no? It's readable? Great. So you can read for yourselves, essentially, that sea change started then in 1856. If there's problems, I believe there's binoculars available somewhere in the technical. No, we didn't bring them. Now, the Common Law Procedure Act of 1854 was the first really substantial legal provision enacted to deal with arbitration. Many provisions in that Act of 1854 dealing with arbitration, and it became the basis of the Arbitration Act 1889, which in itself was the basis for many of the arbitration acts here in the Caribbean. And then you can see the general supervisory power. That was how the courts in many common law countries regarded themselves over arbitration. And of course, with that supervisory power came the right to appeal, or to have the arbitration award judicially reviewed for an error of law, and appeals for errors of law. So to go through those few landmark cases that showed a change of approach, we had Hayman and Darwin's, that if the contract was terminated, the arbitration clause was terminated. That had been the approach up to 1942, but that theory was rejected. And we then had the separability of the arbitration agreement, a nice legal fiction. And then we move over to the Lord Hoffman. And Lord Hoffman in Harbour Assurance in Kansas, which is this one-step adjudication that effectively the parties really were only looking to have their issue determined once, and not to have part of it heard in the court and part of it heard in arbitration. And then the recent Fiona, well, relatively recent Fiona Trust's case and Privalov, all to do with charter parties obtained by bribery, and the language used in the clause, because for many years we had this torturous issue of arbitration clauses that talked about any dispute arising in relation to, in connection with. The permutation was endless. And somewhere along the way, thankfully, here was the stop point where the House of Lords said it's irrelevant. As long as there's some intention to go to arbitration, it doesn't matter about the niceties of the language, the parties should go. And in relation to bribery, unless the bribery was specific to the arbitration agreement could not be attacked and would stand. So that doctrine still stood, that the doctrine of separability, that the arbitration would still take place even if there were allegations of the overriding contract being obtained by fraud. And yep, we can keep moving. And so this brings us to the Untitled model law. And again, tribute should be paid to Dr. Joseph Archibald. He had many choices in front of him as to what way to go forward. The 1996 Arbitration Act was very much being advocated. And I think in my short time that I shared with him in our discussions, he, through his wisdom of many years, determined that the appropriate way to go was with the model law, which I think most of us will agree certainly was the right choice. It's a model that's been adopted in 77 jurisdictions. It gives uniformity, and to follow the theme of this morning about what makes a jurisdiction attractive, if you're German and you can see that the same law exists in BVI relating to arbitration that you're used to, this makes the place appealing. Whereas if you have the 96 Act, well, is this Little England? No. So here in BVI we have the model law, and as it expresses, no court shall intervene except where so provided in this law. So the travaux without water, préparatoire, are the various deliberations that took place in the mid-80s at the United Nations of the various jurists, professors, legal practitioners who got together in the 80s under the auspices of the United Nations Trade Commission to discuss a model law for arbitration. And what is really valuable is Howard Holtzman and Mr. Newhouse have written a book which contains the commentaries about the various articles of the model law. And it is a really useful resource, a bit like Hansard perhaps for parliamentary debates to understand perhaps why a statute was enacted. But there is interesting discussion in there, and effectively they, at that time, and you have to remember time moves on, here we are some nearly 30 years later, at that time there was always a concern about court intervention. And this is why Article 5 is worded as it is. This effective courts do not get involved unless it is in accord with this law. And the timing, as I say, we have the expression about statutes are always speaking. We have moved on into a different era. We heard Dame Janice this morning, the Chief Justice, saying how pro-arbitration the BV Island courts are. And that is a really amazing sea change. 30 years ago, you would not have heard a Chief Justice say, oh yes, we are always here to support the arbitral process, the free will of the parties to do their arbitration as they want. So in 1985, 86, the thinking was, let us restrict court intervention. The English 1996 Act has slightly different wording. It talks about the courts should not intervene. And as I say, the whole purpose is to reduce judicial involvement, increase the powers of the arbitral tribunal, and similar to the travaux préparatoires, we have the Advisory Committee on the Arbitration Law. They did a report which for reference to the 1996 Act, and they too believe that the court intervention should be limited. And Bernard Ricks, Lord Justice Ricks, talks about what those words should not intervene mean, and it related to an intervention in an arbitration rather than an intervention in litigation which threatened the conduct of the arbitration proceedings or the efficacy of the arbitration agreement. And he saw no reason why the court would want to intervene where the parties have freely given their agreement to go to arbitration. So under the model law, we have 4 themes: party autonomy, reduced judicial involvement, increased powers for the arbitral tribunal, and equality of treatment. That you can see when you pick up these very fine copies of the BBI Arbitration Act 2013. And it's quite daunting actually when you do look at it. It's quite a substantial little free book. Louder. It's quite a substantial piece of work, and the Financial Services Commission and Dawn Smith deserve the highest of credit for producing it and making it freely available to the citizens of BVI. Dawn, keep printing. So, but what's interesting is the model law actually starts at page 73. The Act comprises the first 70-odd pages, and the model law is relatively small. And it is worth reading because it isn't that big. And as I say, the main principles set out there are found throughout the model law. But the principal one, of course, being party autonomy. And if I can catch up with the slides, we have party autonomy. And yeah, and that principle is recognized in the New York Convention of 1958, the New York Convention on the Enforcement of Arbitral Awards, made in New York in 1958, which is, as we heard this morning, an amazing piece. I think it was Professor Jones who addressed it. An amazing piece of legislation, effectively, because what it has done, it's the driving force behind international commercial arbitration, because of the fact that you can go into these 159 countries and enforce an award made in this room and have it fully effective, and if you're a winning party, achieve the results of your arbitration. And of course, the driving force in turn behind the New York Convention was the United Nations. It itself had grown enormously. It is encouraging world peace by having effective international commercial trade. And commercial trade, if it's done internationally, needs a place, needs an outlet for resolution of disputes. And that outlet is international commercial arbitration. And the framework that's been established between the New York Convention of 1958 and the Model Law of 1985-86 is amazingly effective. It is why we're here in this room. And it does work. Parties from different jurisdictions, different nationalities, can find themselves a neutral forum with procedures that they can tailor-make for the process, with a panel that they have chosen effectively themselves through their agreement, and they're able to resolve their dispute and achieve a result which is effective. It's all very well getting a result, but it has to be effective. And so, as I say, party autonomy is manifest in procedural neutrality, procedural fairness, efficiency, and flexibility. And again, this whole thing about party autonomy, you see it in the UNCITRAL notes on organizing arbitral tribunals. If and when, hopefully, you get an appointment as an arbitrator, if you're ever wondering how to do it, well, somebody has written the little guide to how to conduct an arbitration tribunal. Again, it's the United Nations Trade Commission. In their early section, they give effect to the notion that the parties are creating this procedure themselves. The parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. That's Article 19 of the Model Law. So this principle is recognized again and again. So parties can be innovative. They can have the fast-track arbitration, where in their original arbitration agreement, or maybe ad hoc later, they determine that they will have points of claim within a week, points of defense with all the accompanying documents within a week. They can make the arbitration happen very quickly if that's what they need. They can have expert determination in order to keep the project going. The Channel Tunnel, when it was being constructed, is a great example of this, because if you had the air conditioning guys saying, look, we think it's your fault, Mr. Contractor, for telling us to put this in the wrong place, we're downing tools, you would have projects that never completed. So this expert determination in the meantime, where the dispute is brought to an expert who makes an interim decision, which can be reopened when the project is over, is a phenomenal way of making sure the project moves along. It was done also in Hong Kong in relation to the building of Kai Tak Airport. Emphasis on particular types of evidence, the type of experts that can be brought, how the experts should deal with each other, the particular qualifications of the tribunal. I had a case in commercial court where it involved insurance and shipping and about the ship. And the judge, when she came in, said, and quite rightly, before we start, ladies and gentlemen, I have to tell you, I know nothing about boats. I don't know one end from the other. And fine, that was very honest of her, but in reality, it would have been great to have had an expert who knew all the terminology which was going to be used. So instead of the case lasting 6 weeks, we might have had an arbitration within a week. But this is the joy of arbitration, the flexibility of choosing the panel, innovative evidentiary procedures, hot tubbing where experts get together and come up with the right answer, living in hope. And the alternative to all of that, of course, is if you are one of the old school and you want your arbitration to look like court, you can do so. You can make all the same, if you're the arbitrator, you can have all the same rules. Or if you're a party to a contract, you want discovery, if the other side are willing to agree to it, then you can have it. So my favorite quote on this whole issue about autonomy, party autonomy, is the case of Baravati and Josephthal. It's a 1994 case out of the States. Short of authorizing trial by battle or ordeal, or more doubtfully, by a panel of 3 monkeys, parties can stipulate to whatever procedures they want to govern the arbitration of their dispute. Parties are free to specify idiosyncratic terms of arbitration as they are to specify any other terms in their contract. And that sums it up. party autonomy. The parties can do what they want in terms of moving forward their dispute to a final award. And this philosophy is used in the enforcement of arbitral awards. This whole thing about the courts striving to uphold the award that the panel have reached. And here is Lord Bingham, Mr. Justice Bingham, as he then was in 1985. As a matter of general approach, the courts strive to uphold arbitration awards. They do not approach them with a meticulous legal eye, endeavoring to pick holes, inconsistencies, and faults in awards, with the objective of upsetting or frustrating the process of arbitration. Far from it, the approach is to read an arbitration award in a reasonable and commercial way, expecting, as is usually the case, that there will be no substantial fault that can be found with it. So the courts are fully behind this. Lord Steyn in the Lesotho Highlands, again expressing the ethos of and this being the 1996 Act. Only those, the court had been given only those essential powers which the court should have, that is, rendering assistance when the arbitrators cannot act in the way of enforcement or procedural steps, or alternatively in the direction of correcting very fundamental errors. So, and then this whole calibration of the balance between judicial intervention, judicial restraint, Baron Mustoe emphasized in the Kenren case, whatever view is taken regarding the correct balance of the relationship between international arbitration and national courts, it is impossible to doubt that at least in some instances, the intervention of the court may not only be permissible, but highly beneficial. So you have this, I use the word calibration, it's a tension. Because on one hand, you have a judge who says, look, I really want to support arbitration, but will they go too far? At the end of the day, it will be left to the judge how he deals with it. But it does appear, from all we have seen to date, what we have heard today so far, that judges are pro-arbitration and will support the process. So the general philosophy of the courts of convention countries is to have a pro-enforcement approach. So you then have inherent jurisdiction, of course. So you have Article 5, which says only in accordance with this law should the courts intervene, but the courts always have inherent jurisdiction. And they may use that to curb procedural excesses that they believe may have occurred. And courts have consistently upheld Article 5 as a mandatory provision. And the court is limited. That's what the decisions to date state. So in the model law, in this fine tome, printed by Dawn Smith and her fine office, you will find that the various articles that deal with court intervention are set out in the ones listed there, dealing with state proceedings, interim measures, appointment of arbitrators, the challenge procedure, all of the ones that you would expect with some experience in the process to find. And then there's also Schedule 2 to the model law, to the Act, which you'll find at the back of the book, page 92. And it does need careful reading, because there is the right of the parties to opt into an appeal on a point of law. There is the right to apply to the court, and the court, of course, is defined in the Act as the High Court, to consolidate arbitrations or to stay one of them pending determination of the other. The power of the court to appoint an arbitrator in default of agreement of the parties to do so. And these decisions are not subject to appeal. And these are, certainly the consolidation is a pretty contentious issue in the arbitration world, whether arbitrations should be consolidated by an application to the court. So just in relation to what you see in the model law, there's two groupings of judicial involvement. One group is the assistance rendered to the arbitration process itself, which we've touched on, and the other relates to the enforcement of the award or the setting aside of it. just to give some illustration of the court's powers and discretions. In Bermuda, there was an arbitration under UNCITRAL rules, and one party wanted the court to appoint, court declined, because whilst there was no provision in the arbitration agreement for the appointment of the arbitrator, the rules themselves provide that you can apply to the Permanent Court of Arbitration. So the judge declined to assist the party. In another case, which is quite interesting, it's a case that features in BVI law reports too, to do with the Megaphone litigation, which took place over a period of about 4 years, not only in BVI, not only in Bermuda, but in arbitration in Zurich, in Geneva, cases to the Privy Council, Germany, Russia, worldwide litigation involving very valuable shares that were the subject of option agreements. And the case had gone well for LV Finance Group, and they had prevailed in Geneva and Zurich in relation to arbitration awards. And what then happened was IPOC, a Bermuda registered company, brought proceedings in Russia in relation to the investment legislation that exists in Russia, saying that these option agreements were not valid. Now, we just had not only arbitration agreements, but actual arbitration awards relating to these option agreements. But they brought in extensive Russian law expert evidence to say that the statutory regime was of a different animal to the investment contracts. And the Bermuda court took jurisdiction to restrain IPOC from proceeding in Russia. You can't see that. They took action, LVFG took action in Bermuda to restrain them from proceeding not only in breach of the arbitration agreement, but in the face of the arbitration award, on the basis that the matter related to an arbitration and prevailed. So there's a very interesting issue of the court taking jurisdiction over a party where there were court proceedings in another country, but all because of the arbitration agreement and the judge's determination that it was appropriate under the New York Convention that he do so. Does the model law occupy the whole field? And if not, is it a legitimate use of the reserved powers of the court flowing from the inherent jurisdiction to intervene in the arbitration process? Well, the courts, of course, have retained their reserved power to support, uphold arbitration agreements. They must do. But again, this point, and I made it about the article is always speaking this language of statutory interpretation, that you view an article in the light of today's language and standards, and the fact that is today the courts will step back and will effectively honor the directive given in Article 5 to an extent, as long as it is effectively doing justice and giving support to the arbitral process. So you have, for the purpose of setting aside arbitral awards, further discretion. It's set out in Article 34, and of course it's always been the subject of many a lecture and many very learned article that an arbitral award may be set aside, not will be, should be, if they don't meet these particular grounds. It's maybe. So effectively you're starting with the premise that the court will enforce, and it may refuse or may set aside if one of the specified grounds is raised. But if the specified ground is raised, it may still be not effective to stop the award being enforced. This is just the relevant 34. And effectively, you can have various objections to the enforcement of an award. Many of them can be very petty, such as the place is not properly specified on the award, not properly signed. Females on the panel, that's an old saw about how Saudi Arabia won't enforce awards because women on the panel. Failure of certain proofs. Again, left to the discretion of the judge. This is an Irish case where the court refused to be following the UCOS example that Hussein was talking about, that the Irish court refused to take jurisdiction on the basis that the case had no real connection to Ireland, that the UCOS attempt to enforce the award was really because they just looked for some respectable jurisdiction. So, question of threshold, that matters under appeal to the Irish Supreme Court. So, conclusion. So, the model law created to support international trade. It came into being when the courts were evolving, and maybe the courts still are. But certainly, as I was highlighting, the model law didn't anticipate this amazing pro-arbitration approach today. So maybe we don't need, as I describe it, the leash of Article 5 anymore, because from what we've heard and the amazing approach of the courts, BVI is on its way to showing the world that this is a pro-enforcement jurisdiction, and Article 5 has very limited use in that regard. Thank you.